And now I would request our two young friends here, KANUGA and SHALAKA. SHALAKA means a stone, huh? So don't bend stones. Oh, okay, so please start.
Many thanks, Suresh, for introducing us. It's pretty interesting. Shashi just mentioned that in the US, an advantage of ad hoc arbitration is additional flexibility. I think most of us over here in this room, Indian practicing lawyers or litigants, or anyway aware of litigation, would know that that additional flexibility in ad hoc arbitration has left the experience of arbitration in India wanting. Most of the arbitration in India is ad hoc, and let's face facts, it's not met the needs of the hour. We are definitely moving towards institutional arbitration. But going forward, let me quickly introduce the firm. We are Nishith Desai Associates. My name is SAHIL KANUGA, my colleague Shalaka PATEL. We are a law firm that is based in Bombay with offices in Bangalore, Delhi, Munich, Singapore, and the US in Silicon Valley. We focus on cross-border matters. We essentially ensure that our matters are complex matters, heavily researched matters. In your packet, you will find a little bit of literature about the kind of work we do. It's not run-of-the-mill work. We enjoy it. That's the kind of work we actually enjoy doing. Our focus on the presentation today is the past, the present, and the future of arbitration in India. There is no doubt that given the backlog in the courts today, arbitration is the way litigation will develop in India. Let's see where we came from, where we are, and where we're going to go.
Thank you, Sahil. I think our topic is quite ambitious because it seems to suggest that it covers the arbitration jurisprudence in India across the span. But as most of you would be aware, in the last 2 years, arbitration jurisprudence, especially for international arbitration, has changed quite a bit in India because of Banquet, which Shashi mentioned as well. The law in India in the past, and I'm going to just go over this very briefly because I think that most of you will be aware of this, was the judgment that governed then was Bhatia International as well as there was venture group. So Bhatia International had said that even for foreign seated arbitrations, because there is no remedy otherwise available under the Act, under the 96 Act, you could grant interim reliefs. And then venture group went a step further and said you could even set aside a foreign award in India, although both these provisions are in Part 1 of the Act. And this had led to a lot of bad press for India and international arbitrations seated outside India, but with Indian parties or with arbitrations that had very little connection with India. Even when the governing law was in India or the seat was in India, Indian courts would have jurisdiction to grant interim reliefs as a result of this decision. And some would say that there was a reason that this decision was there, which is because the assets are located in India. What would a party do otherwise? To a great extent, Banquet changed this because it streamlined the regime in India with the regime in the rest of the world in terms of sort of dealing with the fact that Part 1 and 2 are separate and that in India for interim reliefs, if it's a foreign seated arbitration, the right court to go to would be the court of the seat and not India. Some of the things that Banquet did though, which are not as beneficial for the jurisprudence, is of course that what does one do when assets are in India, and also Banquet applies prospectively for agreements which are from the date of September 6, 2012. So for pre-Banquet decisions, the law is still the law in the past, and for post-Banquet agreements, the law is in terms of Banquet. So in a sense, there are two parallel regimes today in India, and I think it's for the legislature, of course, to be able to change this, and we also talk about this a little ahead. The Law Commission has recommended some changes and amendments to the Arbitration Act, one of which is to say that perhaps we should have interim relief measures in India as well.
Now think about it from this point of view. When a client comes to you and says, oh, guess what, I have a dispute with my supplier who sits abroad. There's an arbitration agreement and I'd like to arbitrate. The first question is not, where's your seat or where's your, what kind of agreement it is what's the date of the agreement. Because according to that, you will apply the law. Bit of an anticlimax, but I think that's where we are today. After Banquet, what advice that was being given out by lawyers was, if you want interim relief, choose a seat in India. If you think you can do without interim relief, and therefore no Indian courts at all, go outside India. A foreign investor had to either choose between interim relief or a fast arbitration. He couldn't have both of them. Between 2013 and 2014, it seemed as if the wind was in the sails of Indian arbitration. There was a bunch of cases that basically said arbitration is something that the courts will respect. Going forward, we will ensure that we don't interfere in Indian arbitration. There was the case of Enacon, where emphasis on seat was permitted and arbitration was permitted. Plural controls took arbitration one step further. There were non-signatories to an arbitration agreement that were permitted to be joined. Although that's the exception and not the rule, but the law is actually set up pretty well now. You can actually bring non-signatories in. Fraud. You saw people making allegations of fraud just to get out of an arbitration agreement. This was because of the judgment called Arbitration. Who realized the game we were up to and basically diluted that. So that wasn't the case of MSN Satellite. SHALAKA is absolutely spot on. In the Law Commission report, they actually deal with this and they say that we'd like to make fraud and arbitrability. But that's not passed yet. There was a case a couple of months ago called Western Gecko. So there's a reason why I say opening a Pandora's box. ONDC SOPITES basically talked about public policy, and there were 4 subheads that were created in ONDC SOPITES. Fundamental policy of Indian law, contrary to interests of India, justice or morality, and patently illegal. The 4th one over here, patently illegal, is the famous ONGC SOPITES petition. And this is the one that Indian courts were using with a view to interfere in foreign affairs. This was actually checked when PATEL mistakenly gave a judgment and was corrected in Sri Lanka by a 3-judge bench of the Supreme Court. The case of Western Gecko that I now refer to talks about fundamental policy of Indian law. This will apply to domestic arbitrations, that is arbitrations in India, as well as foreign seated arbitrations. This is a time bomb. The reason I say that is because when you describe fundamental policy of India, they give an inclusive definition that says there must be a judicial approach, there must be principles of natural justice, and it must comply with Webunar+'s principle of reasonableness. Keep in mind, these are tests that you can fail on discretionary basis. This is a judgment that will go forward and will probably set the tone for arbitration in India. The Law Commission report, Justice A.P. Shah, famous former Chief Justice of the Delhi High Court, is a known pro-arbitration man. He set up the Delhi High Court Mediation Center and is well known for his pro-arbitration stance. He was responsible for this particular report. He is the chairman of the Law Commission, and we dealt with him personally when he was coming out with this particular report. Believe it or not, the entire report was ready with him in 2 to 3 months' time. That's no mean feat, given what arbitration in India was. He took inputs from the top litigators in the country, ensured that every single loophole that Indian arbitration saw was plugged. Let's discuss some of the places where we see arbitration going with this Law Commission report implemented, if it gets implemented. Institutional arbitration. Ad hoc doesn't work in India. I think that much is pretty much established. Why not try institutional? Courts are actually going to push people to go for institutional arbitration.
We should pause here and just, I know that there's a question from this, but maybe we should pause here and perhaps just ask the audience, in your experience in arbitrating in India, do you have a preference of one over the other, time and efficiency? I was speaking with some people in the audience and they mentioned that depending on the area or industry, there is sometimes a preference to ad hoc over institutional as well.
Is that true? Does anyone prefer ad hoc over institutional? Tell me why.
It offers a lot more flexibility. You save down, you save on costs, and as far as India goes, I deal with a lot of ICA arbitrations, and I find the ICA as inefficient as perhaps an ad hoc arbitration. A lot depends on who you appoint as your arbitrators, whether it's efficient or not.
Very, very good point. Who do you appoint as an ad hoc arbitrator? That can make or break an arbitration. Let's not forget that at the end of the day, why do people choose arbitration? Speedy, effective dispute resolution. We don't want to take chances depending on who you appoint. Is he a good man? Is he a busy man? Are the three of them so busy that they'll give you date every 6 months and 1 year? When you appoint a man to be your arbitrator, there is an expectation that he will sit when available and sort out your case in a speedy and effective manner while giving both parties the opportunity to put their best foot forward. If you've had a good case in ad hoc arbitration, as I have also, you're a lucky man. In institutional arbitration, it's not unusual for an arbitration to be over. If it's a sole arbitrator, 9 to 12 months. If it's a 3-member tribunal, 2 to 3 years. I agree it's slightly aggressive, but institutional arbitration does make it happen. The things that take place in India for recording of evidence, which takes 3 months, 6 months, 9 months, I've seen it done in 5 days in institutional arbitration. But again, that's a personal experience. So you also have your experiences there. Going forward, the Law Commission proposes arbitration benches before the High Court. It proposes incorporation of a brand new cost regime directly from the UK courts. Not only does this give you the actual costs that you actually incur in an arbitration, it actually takes a look at the conduct of the parties. Did you not settle a matter when a reasonable offer was made to you? What was your conduct in delaying the proceedings? Did you not even consider options placed before you? These are things that Indian arbitration has never seen before. So the Indian arbitration scenario will have to mature to be able to deal with something like this. Disclosures by the arbitral tribunal. Indian arbitration is particularly susceptible to disclosures. Everybody feels that the man sitting up there on the bench may not be the best man for other reasons. The disclosures that are proposed to be made are in line with IDA conflict of interest rules. They are possibly the best rules in India. Enforceability is something that will remain to be seen, but it's a step in the right direction. Enforceability, again, is a bit of a test in emergency arbitration. Total codes is now being given legislative sanction by saying parties to an arbitration, you can bring parties claiming through a particular party. There is an obligation put upon parties to cooperate at every step. There are specific provisions to set aside and challenge awards. 34, ONGC 45, 48, it's all being tightened up. The automatic stay that is granted at the end of an arbitration when you file a 34 is being removed. What does this mean for Indian arbitration? Is it coming of age? Are we seeing it fall in line with international trends? Possibly. Is this law yet? The answer is no. We spoke with Justice Shah and we asked him, when do you see this becoming law? In his view, there is a very good chance it will become law coming this year. We're 3 months away from Indian arbitration change. Every single arbitration agreement that is in your agreements will be bound by this new law. Are you ready for it? That's the question. International arbitration is very different from domestic arbitration. You will not have extensive adjournments, you will not have extensive disclosures as there are in the US, but it will slowly come. Be ready for it. Happy to answer any questions that you may have.
I just perhaps want to mention one of the other provisions that the Law Commission has suggested is the emergency arbitration procedure, and just perhaps end with one effective example of a case that we handled where a client came to us about 2 days into a major dispute over a fraud-related issue, and there was a requirement to, there was an SIAC clause, and there was a requirement to appoint an emergency arbitrator and get an interim award because a bank guarantee was going to be enforced. And within a span of a few hours, SIAC was informed, and arbitrator was appointed, and within 24 hours of that, there was a hearing, and which was followed by an emergency arbitrator's decision. And this sort of swiftness is perhaps rather rare in interim proceedings otherwise outside of arbitration. So this is something that I think will be a constructive point for India to consider going forward if it does happen. So, yeah.
Any other questions to any of the two friends here, and also to any questions? Now we are giving open discussion.
Regarding arbitration, which you said, arbitrators are appointed by the courts, but different arbitrators charge differently. Is there any provision for charge that should be given the same for all litigants?
So that's a good question, and costs are a serious concern.
I don't know how it is done in the US because it's the same thing.
So in India, the cost of an arbitrator is definitely a concern. People have started raising it more and more. It is because of this that the proposed law commission report proposes to have a model fee clause that is recommended. This is in the nature of guidelines. It can never be binding, unfortunately. You can't force an arbitrator to accept fees that are not acceptable to him. However, there is always an option that when you go before a court and a court is appointing the arbitrator, you have some sort of an indication what that nature of arbitrator charges. So for example, if it's a Supreme Court judge, you know it's going to be a lack of hearing at least. So given the amount at stake,
what happens in such things, the court should basically give a limit to the number of meetings the arbitrators hold, because they usually hold a meeting for some time and then they adjourn it, because it's 1 lakh per hearing or 3 lakhs per hearing.
that's actually a good point also. Unnecessary hearings are something that the Law Commission report also proposes to deal with. And it encourages arbitrators to have teleconferences, video conferences, and not necessarily have physical hearings. Because you don't have to fly the arbitrator down, give him a 5-star for a 15-minute procedure and hearing. You can very well do the same thing on the phone.
Generally, arbitrators are appointed in the city itself, so it's not necessary to fly them down.
In international arbitrations, you will find them from all over the world, not just from India.
Let's hear.
This is the US view.
All right, to answer, first of all, you said something, and I want to make sure I'm on the same page with you. The court doesn't appoint the arbitrator. It's either the institution, if the parties cannot agree to an arbitrator. So the parties have some control at the beginning to choose the arbitrator they want. Now, the fees are there. I can't deny that, and I won't. And it will vary with the type of expertise you might need in a particular situation, or it may vary how quickly you need somebody. So, and the complexity of your case is really going to be the issue. If it's more complex, it will require more time, and that will be where you're going to incur more fees. I don't know if that answered your question on that point.
No, what you are speaking on is about institutional arbitration.
Yeah.
Here in India, the court also appoint an arbitrator depending on the agreement clause. So those arbitrators, basically someone charges.
My dear friend, I have understood your question about the charges. Now there are 3 things which our panel members have said. Number 1, that in institutional arbitration, the fees are set. Already it is laid down. In the ad hoc arbitration, as I have understood our friend, it has to be negotiated beforehand. So when the arbitration process is set, at that time everything is determined. So the question of fees Now the third thing which I learned from today in the Law Commission's report, where Justice Shah has recommended that it should be also harmonized, uniformized, and you use the word brand, no? Guidelines. But the point is, I will tell you one thing about my experience. We are setting up in Indian Merchants Chamber arbitration EDR center. In that center, we are going to do two things which the friends have cautioned us. Number one, that the fees will be set. Second thing, it will be all calendared as very well suggested by all the friends. It will be calendared and no kind of the frequent sort of adjournment will be given. It will be calendared very particularly, and the arbitrator who commit will have to sign that they will have to finish within this time. And the signature not only will be from them, and that the institution will insist from an arbitrator that you will finish within this time. This is the point which London arbitration has incorporated, and we are going to incorporate too. So this is the point which I may add to everybody's thinking.
Thank you, sir. But ADR was something which was started by the Bombay High Court in 2004. But then it never began.
Others also may ask the question.
And may I point one thing out, because I don't know if this was very clear. You know, these tips, such as picking the seat of the arbitration, these are facts that are negotiated between the two parties. And where certain things happen may be the party that has the higher bargaining ability may have the power to decide the seat. So it may be in India. It may not be if the Indian party doesn't have the bargaining power to, get that in. So it's a wish list. So I wanted that to be clear. So next question.
Yeah, please. Please first introduce yourself, and second, make it very brief and only the question, not the comment.
I'm Siddhan Varshit from outside Madras. I had a question about yes. So since you talked about choice for a foreign party to either choose an Indian seat or a foreign seat, in that context, I had a question. Say if a foreign company enters into a contract through an Indian subsidiary, the other party is also an Indian company. So technically, you have two Indian parties. Under the Indian law, can they choose a foreign seat?
I'll answer that. People have taken a view that two Indians can arbitrate abroad. You're absolutely right when you say that there is no specific provision enabling you in the Arbitration and Conciliation Act. But the contrary view is that there is no provision barring you from doing the same thing. The question then becomes: let's assume two Indians arbitrate in Singapore, and the award passed over there is a Singapore award. Now, obviously, your substantive law will be Indian law. What about the imperial law? When you bring that award into India and you seek to enforce it, will there be an argument at the time of enforcement that this is against the public policy of India? No, unfortunately, this is something I haven't seen. It's an untested proposition. Some people feel you can do it and go get away with it. Either get it. It's not a simple. I haven't seen it, but I think so. There's a way.
But sir, personally, I feel
the public policy is the most unruly horse, and absolutely, I'll describe what the Supreme Court many years ago.
so. Now, any next question? Please make it short. Introduce yourself.
Regarding enforcing the award which is created,
Introduce yourself.
I'm Prasad from EMI. Regarding enforcing the award which is given by the company, if it has to go back to the courts, then how long does it take to actually get the money in the bank? That's one. And secondly, is there any other country which will override this? Like India would be acceptable to this enforcing the award, but how about other countries? Would the US would accept the enforcement of the award which is given by
Well, the key to that, and the answer to that, is whether they're a signatory to the New York Convention. And and if they are, then they're obligated to enforce it. And as far as going to get the assets and how long it takes to get the money in the bank, that's your next step, after you've got the order from the court.
What's the time frame?
Anything else? Yes, from this side?
I just want to add one thing there is that unfortunately in India there's one more step to this, being that not only do you have to be an NY convention country, but you also have to be notified in the official gazette as a country the country from where an award is recognized, and it has to be a reciprocal territory. So that's another step. But time, I think it takes about 18 months or more.
It's like sitting in a taxi and saying, take me to Wankhede. If you leave at 6 p.m., it'll take you 2 hours. If you leave at 10:30 p.m., it'll take you 1 hour. It depends on the traffic jam. It depends which port you're before. Too many variables to give an accurate timeline. It's not unusual to see proceedings take even 3 years before the primary court. All those proceedings are obviously subject to challenge all the way up to the Supreme Court.
Final 2 questions. This side, anybody? This side, anybody? Yes?
This question is about Banquet. I just wanted to know the question which my friend.
You are from which group?
I am Mayur Shetty from Rajani Singhania Partners. So I have this question which my friend just put it. The scenario in India is very unclear as to whether when there are 2 Indian citizen or entities arbitrating whether they can select a foreign seat. I think EDU deals with it, but it only says it won't be an international commercial arbitration. So my question to you is, how does US deal with it? If there are 2 American entities, are they allowed to have a foreign seat of arbitration?
It's usually domestic.
So is it barred by law that they cannot choose a foreign seat?
It's not, but it's usually domestic.
Okay. Thank you.
As a businessman, I think, and I tend to be corrected by the experts, that the determining factor of jurisdiction will be seat of arbitration. Supposing even we contract here for, say, Singapore, for example, because arbitration is a mutual process. We both agree by an agreement for a particular seat of arbitration. So this is my thinking, but I tend to be corrected.
Actually, it is spot on. Arbitration is mutual. It depends on party autonomy. If 2 Indians choose to arbitrate before the SIAC in Singapore, chances are it is something that will be respected by a court, or even SIAC in Singapore will go ahead and administer that arbitration. That's not a problem. The problem is once you get the award, is it as good an award? Is it worth its weight in gold? Or did you go through the process of an arbitration to come into India and have it set aside? That aspect of it remains untested. And you might very well have clarity going forward. You will find, I'm sure there are enough agreements out there with 2 Indians having foreign seated arbitrations. I've seen some arbitration agreements like that. Let's see what happens in a dispute scenario. One point to keep in mind is, with the Law Commission report coming out, could the Commission have clarified this position one way or the other? I think they had an opportunity and they chose. Thank you.
So, friends, we have had a good interaction, and of course, on tea, you can discuss with them more often, argue, debate, discuss, write to them. They've already given their emails. You can also discuss with them. And let me tell you, I'm very happy with the kind of the discussion. You see, let us be enlightened, because this is going to come in a bigger way. Arbitration is going to come in a bigger way, and even when the courts are encouraging the Law Commission's report, I am very glad about one thing. The clear distinction between past, present, and future, which has been brought about in the presentation, has been so clear, so concise, and so convincing. So let me also compliment them. And about the international and the 10 tips. The 10 tips can make the things very simple, and it can give us to a clear basic guidelines that what we should do. And arbitration, after all, friends, is a mutuality. And in a mutual way, the arbitration has to become a very kind of a very accepted practice. Apart from that, I found this is my question to you also, Shashi, in America I found, in American Arbitration Association, I found a clause that mediation, first is mediation, failing mediation it is arbitration. So in America I found a particular clause that first they mediate and then they arbitrate. Am I right?
You're correct. You're correct.
Why do you not? So let us do more of mediation. We are Indians, so we must have more.
Well, and that can be a first step, especially if the parties are, able to come to a mutual agreement. But again, it may not be binding, so.
No, but it is a clause.
There is a clause, yes.
There's a clause is recommended.
There is a clause, yes. And I will point out that many of these institutions, on their websites, they do have a sample clause, but you need counsel to help you and guide you. And that's it.
Here is Dr.
Just maybe comments and you said questions only, so that's why.
No problem. Doctor, your
My name is Captain Gupta. I am a practicing arbitrator, so I'd just like to comment on my own dissatisfaction with the scene. A friend was talking about the Nishith Model Code after which our Act President drafted. Before the Nishith Model Code came in, the Nishith report said that by and large their observation is that commercial people in the East like to mediate and compromise, and they are not as litigious as people in the West. While that is true of the traditional Indian community, we have the stock exchange arbitration, the bond exchange arbitration spoke very well. Within just a few days, no lawyers appearing, or very few lawyers appearing. The friend said here about adjournments of the by arbitrators and arbitrators charging for the full. Very true. But in my limited experience, I also find that lawyers in India tend to be more adversarial than need be in an arbitration. They also seek adjournments at short notice and for no rhyme or reason at all. I've had experiences of senior counsel appearing in maritime arbitrations and saying, I don't have dates for 6 months. Just 3 days ago, I had to very gently tell this very senior counsel that if you don't have dates for 6 months, maybe you should return the brief and let somebody who's available do it. So what we need is, I know the Law Commission report, if implemented, it will take time, but we need more than the change in law, we need a change of mindset, both in the commercial community and also in the legal fraternity. Without that, we will not be able to move forward in the business.
I welcome Captain Gupta's comments, and that's the point. We do not have to be dilatory, but we have to be resolutory, and which is the point, and which is very well said. Now I would request Rakhi Patna to give over.
As we come to the end of the program, on behalf of our IACC office bearers and the Secretariat, and I must mention our partner for this event was Mr. Desai Associates, I express my heartfelt thanks to all of you who, in spite of your busy schedule, you've come down and attended the program and contributed to the session today. Thank you so very much. I would also like to extend our sincere thanks and appreciation to our speakers, and a special thanks to the session chairman, because he kindly obliged us by accepting our request to be the session chairman, and I did not say anything how he moderated the session. Thank you so much, sir. Thank you. And before you all leave, I would request you to kindly collect the invitation for our upcoming event, the KRISHI, which is on International Agriculture Trade Fair and Conference, supported by IACC from 14th to 18th of November there in Nashik. And we hope you and your colleagues can participate in this event. We'll keep you updated as and when the program gets finalized. Thank you so much and have a wonderful evening. Thank you so much.